Someone make it make sense.
Probably a couple.
Hello, everybody. Welcome. Shout out to Kane. Shout out to James. Kane is saying that my voice puts him to sleep. I thought I talked too fast for you. So anyway, but happy to see you guys. We've got a little fun, just a quick little thing here. Start off on a good foot with little Gabby. Wait till you guys see little Gabby with her ears. Oh my God. There she is. She's a champion, you guys. She's a champion.
Next in the 8-inch class, Gabby, the Papillon, handled by Andrea Samuels from Cape Coral, Florida.
Watch, guys.
And Andrea is also the handler of Fortune. So these are two dogs, same breed, same.
If it's not the cutest thing. And she's so excited, but she's not barking, but she's so excited.
Handler duking it out here head to head right at the end of the class.
And this dog is also a national agility champion. Look at her drive that dog walk.
I think we can see why.
Spectacular. That was absolutely spectacular. Same thing with these weed poles.
Oh my God. Look. Oh my God.
We can't hear Andrea at all, but she is definitely talking to her while they're running this. Wow. That was spectacular. Absolutely.
It was spectacular. I've seen this a number of times, and every single time I love this so much. Oh my God. So she's so fast. Sometimes it's like you can't even see her, but also the way that she's not heavy enough to make the teeter-totter go. And there's just so many things. And they're going to show a slow-mo here of her form doing the sticky things.
Breathtaking.
Oh, look how excited she is. Oh.
Now you see why they're national champions. Watch this dog. This dog just keeps accelerating.
That's not sped up video. That is real time.
It sure feels like they sped it up, but that is not what happened. And watch this weed pole.
Look at her focus, guys.
Really hunkers down a bit going through them and just drives through those poles.
Oh my God. One more time. I love this so much. And thank you so much, James, for the super chat. And Kane says I'm putting him to sleep for 4 months. Well, maybe I need to talk faster then to keep you awake. Okay. Let's watch more.
Next,
oh my God,
in the 8-inch class,
part of the reason she's so good is because her ears, they're wings, and they help her fly. You know, she believes she can fly.
The Papillon, so handled by Andrea Samuels from Cape Coral, Florida.
And Andrea is also the handler of Fortune. So these are two dogs, same breed, same handler, duking it out here head to head right at the end of the class.
And this dog is also a national agility champion. Look at her drive that dog walk.
I think we can see why.
Spectacular. That was absolutely spectacular. Same thing with these weed poles.
Oh my God. Look at that. Wow. I mean, Lincoln will miss it, right? Wow.
We can't hear Andrea at all, but she is definitely talking to her while they're running this.
Wow.
Wow. That was spectacular. Absolutely breathtaking.
It is.
Now you see why they're national champions.
Oh my God, she's
watch this dog. This dog just keeps accelerating.
That's not sped up video. That is
crazy.
Real time.
Sure feels like they sped it up, but that is not what happened. And watch this
Look at her.
She really hunkers down a bit going through them and just drives through those poles. Andrea is saying a lot to her while they're out there running, but a lot of her body language.
In the 12-inch class,
it's my favorite thing. I love it so much. Meg saw this one earlier. I love Gabby. I'm a big fan. I'm a big fan of Gabby's. It's super impressive. She's so cute with her ears. In her heart, she's got so much heart energy, which I just love. So speaking of heart energy, is that a segue? Not really. We're going to jump on over to Lori, making her debut in court, in her lawyer outfit. And also I do have some updates as well from today. So we're going to get on into this, which is pretty interesting here. So this is from yesterday. Thank you. So James sending us a super chat for Gabby. Yay. I know. Round of applause for Gabby. She's amazing. We love her so much. The crowd goes wild. Exactly. I know. We can watch it anytime you guys want. I'm going to keep it queued up, ready to go. Yes, they got a jury. Yes, they did. They got a jury. Yep. Oh, and for anyone who didn't hear, they finished the Canton Police Department, obviously segueing to read here briefly. The Canton Police Department, like investigative, report. I think it's what it's called. What's the actual title? Let me see. I've got the document. It's 206 pages. Where is it? Yeah, the police. It's the audit report, the Canton Police audit report. So I've got that. So I was gonna do that, but I was like, I want to do Lori. I think it's your phone. I don't see anything, Meg. There is shout out to Iowa Backyard Cam, by the way, who let us know there's a new iOS update. So that could have something to do with it. I updated today. So it says there's 8 new emoji. I couldn't find them. Does anyone know what the new emoji are? But yes, they got a jury here. And I feel like there was some other update. I don't remember what it was. Anyway, I'll think of it.
Are in the back as spectators, might not be able to.
Jury selection. Well, jury selection was streaming already today because we covered it for Karen Reed. Now they can't show them voir direing individual jurors. They can't do that. No one can do that. But what is it? WC. Anyway, there's a local news channel that's been given permission to stream the non-voir dire, which is when Judge Bev just asks the questions to the jurors and reads them the statement of the case. And we covered that earlier today. And I would imagine that's going to be the same for every day, where they can have the camera on for that. And then they have to turn it off for individual voir dire. No, there's a new one, Meg. I know there was one 2 weeks ago. There's another new one. I couldn't believe it either. There's another new one. Check. Go ahead, check again. Check again. Yeah, I don't know. I mean, they can't show the individual jurors. So what they would be allowed to show would be what we saw today. Oh, interesting. Huh. Weird. That's weird. Because I did update. I remember there was like 2 weeks ago, there was an update. In fact, I think we talked about it on one of the live streams, but there was another one today. That's interesting. Yeah, Daryl Brooks was definitely insane.
We'll be in the courtroom tomorrow during the jury selection process. I'm just letting you know. Let's talk about some of these. First of all, for the record, I did get the defendant's notice of objection to the jury questionnaire that was filed on March 20th. The defendant was objecting to, I guess, the phrasing of the allegations that the state has made, and then requested that the fact that she denies the allegation be bolded and underlined it in the questionnaire. I did get your objection. I guess de facto, I overruled the objection in the question.
Yeah, and I remember that we covered those filings. By the way, I am seeing not just on, I'm not even looking at Long Crime. I'm seeing like for other channels like NBC Boston. So in other words, for today, only there was one certain local news outlet that was able to have cameras, I guess. And it looks like other cameras are now in. So like I'm seeing, for example, for tomorrow, upcoming, the live stream of the hearing, but it looks like it's going to be after the fact. I don't know. I'll keep looking here and seeing.
Chair went out as proposed. Next, I have defendant's motion in limine to preclude expert testimony of Daniel Coons dated March 10th. Let me ask the state. That's Detective Daniel Coons of the Chandler Police Department. Is he going to be testifying as an expert?
Your Honor, we did notice him as an expert in terms of his background and training and testifying as to trajectory.
Yeah, the law and crime, they're going to have coverage of what we have, of what they didn't get today. Like law and crime did not have cameras there today. Neither did Court TV. It was just that one local news channel, like WCTV, whatever it is. Anyway, we watched it, but it looks like they're going to have cameras there tomorrow. But anyway, but the point being, they're going to be able to. They're not going to be able to show anything more than what was already shown, because they can't show the individual voir dire.
So we did that in abundance of caution, but we did supplement and provide the defense with the background of that. It was provided to the defense more than 30 days before trial. And defense has interviewed him since then.
What was the last part?
The defense has interviewed him since then.
Okay. So, Ms. Daybell, what's the objection?
So for 5 years, of course, he's been on the witness list to
There
be
she
a regular
is.
detective, and now he's being put on as an expert. I feel like to give his opinion instead of just stating the facts. So that was my main concern. I don't understand how the trajectory has anything to do with conspiracy. So I object in that way as well.
All right. Has he testified in that regard in the past?
Yes, I believe so, Your Honor. He has been trained in that area and taught in that area. And his relevance, Your Honor, would be because the defense has claimed a self-defense claim as well. It's relevant for that.
Can the state provide me what his opinion is, and does he have a CV?
He does not have a CV. We did actually put the opinion in the supplemental 15.1 that I filed, along with his,
Okay.
I believe, background and training in that as well. So
I guess let me flesh this out a little bit more. Let me ask the defendant, you've said a couple different things. Are you saying he's not qualified as an expert, or just that the disclosure came in late and you don't think his opinion is relevant?
Well, one, I don't think his opinion is relevant, but also the fact that he's named as a
Got a suit coat,
firearms
guys.
expert. So I don't know if he took a weekend class and that made him a firearms expert. I don't know what his experience was.
Oh, like a Trooper Paul situation. Kane, I don't know. It's not Twiz's birthday, but Kane is pulling out all the stuff. I do appreciate it. I think it's great. I love that Kane's going to have to get really creative with the asking to be a mod thing. But it'll be really interesting to see what all he can come up with here. But I wasn't pouring it yesterday. But I appreciate and I love all the effort. It's really entertaining. And James sending a super chat for Twiz's not birthday. Where is Twiz? Anyway.
With that in his CV, it just says firearms expert. So
Did you ask him those questions? Was it you that interviewed him or your investigator?
my investigator interviewed him.
Do you know if he asked questions regarding his
I'm not
background,
sure.
training, or expertise?
Okay, so I haven't listened to that yet, so I'm not quite sure. My concern was that he was a regular detective on the witness list for 5 years, and then 30 days before trial, he's now an expert so that he can give his opinion. And I just thought that was my objection.
Thank you. And I
Well, if that was your basis of the objection on the timeliness of it, the state did comply with the rules as far as notice prior to trial.
This is an expert for the state. She's the one objecting to the expert for the state.
And giving some sort of summary of what his opinion testimony would be. I'll take a look at it. It doesn't sound like we need any sort of Daubert hearing, but I'll take a look at it. So let's table that for now. Next I have defendant's motion to.
I have to say, I'm glad that they have a jury because this is gonna be much better. It's possible they'll be done with her trial before Karen Reed starts. Fingers crossed, right?
Close 404B evidence dated March 14 and the state's response dated March 23. I don't know that the evidence that the state is offering to introduce necessarily 404B bad act per se, but let me hear from the defendant. You got her response?
What is that? Oh, that's a fan? What is that? I thought at first it was a bunny, and then I thought it was, I don't know what I thought. The thing, okay, so see where the judge is, and then see to the left of the judge, there's the girl with the curly hair, and then there's a screen, and then there's a thing. Anyway, I was like, what is that? And then I realized it's just like a fan, or it just holds up the screen. So never mind. I thought it was something exciting, and it's not.
I did.
All right.
You guys are funny. Totally shocking.
So what specific bad acts do you think should be precluded? Or were you just asking for disclosure of what they were actually intending on introducing?
I was asking for a disclosure of 404B that they planned on introducing at trial, and what I got was another theory of the case. So I didn't think that any of it was 404B relevant.
Well, I think I agree with you in so much as what was listed in their response, I wouldn't necessarily characterize as 404B evidence. But you have received that, and now you're aware of what they plan on introducing.
Okay.
Someone
First in the chat to without looking it up, no cheating, to say what is 404B? What is 404B? You get 1 billion squirrel points. 1 billion squirrel points. First to say 404B. What is that? What is that pointing to? What's Mr. T? Like the dude from the commercials back in the day? Yeah, I'm surprised it's not the same courtroom. Now, there was talk in one of the other hearings about being in a different courtroom. So it's entirely possible that the courtroom they're in now and the courtroom it's entirely possible that the courtroom they'll be in for trial could be the same one. I do remember them talking about that. There's something about moving courtrooms. So that's common. So we'll see. But it is Maricopa County, so. Lack of foundation, that's a good guess, Flash. That's an objection, though. Not wearing underwear. 404B, yes. Federal rules of evidence. Or, every state has also their own rules of evidence, but they're pretty much the same in terms of, in other words, 404B is 404B. So it's never going to be different anywhere else. So it's just that sometimes they just might have a different, like in Idaho, for example, the numbering system might be different, but the rules are exactly the same. Meg lived in Maricopa. You're the closest one so far. Too fast. Well done. I would say, I'm going to say that's close enough. Ding, ding, ding. Woo! Shout out to Too Fast. You get 1 billion scroll points. I'm going to say that's the closest one. So 404B has a lot of different things, but the easiest way to think about it, especially in order to differentiate it from the other similar rules, is 404B is going to be your prior bad acts / character evidence. So we'll do a brief little review here. So 403, right? Excluding relevant evidence for prejudice, confusion, waste of time. We hear about that all the time. Prejudice, confusion, waste of time. That's also your balancing act. Prejudice versus, or prejudicial versus probative, right? We talk about that all the time. That's your 403. 404A is your character evidence. So you were on the right track there, Too Fast. 404A is your character evidence. 404B is your other crimes, wrongs, or bad acts. So specifically to Lori, right? 404B. And think about Brian Koberger too, right? There's the 404B there with the traffic stop, right? So again, 403 is, and there's no A and B, it's just 403. 403 is excluding relevant evidence for confusion, prejudice, or waste of time, and then also your balancing test, more prejudicial than probative, vice versa. And then 404 has 404A, which is your character evidence, and 404B, which is your prior bad acts. So good job, guys. Good job. Well, and well done to Too Fast. Woo!
What?
Too Fast. You can join the ranks of Gabby today.
Correct.
I don't think I need to make a ruling on that. If there's evidentiary objections, hearsay, foundation, those types of things will be taken up when the state elicits or attempts to elicit that information. I have next defendant's motion to exclude state witnesses dated March 14 of 2025 and the state's response, specifically defendants requesting to exclude Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. The state filed a response on why. Let me just make sure I'm looking at the right one.
You send your bat signal out? Is this for Heather? Is this for Twiz? We can also do the scroll call. Hold on. Calling all squirrels. Okay, that's funny. That's funny. Right. Yeah. See, you were close. Yeah, you're close. Because 4038, yeah. Or sorry, 404A. So you had the right number. So that was close. That was, and honestly, yeah, that was well done. So, and when people talk about 404 without giving a subsection, right? When they just say 404, they're going to be saying like character evidence and prior bad acts, right? Grouped together because it's not it's not specific until you break it down into the subsection. So, so well done. Too fast. The scroll call?
The state's going to offer some sort of testimony from these three witnesses that are going to talk about to go toward the element of premeditation and or motive. So what is your objection specifically?
Mine, Your Honor?
Yes.
Oh, my objection was that after their interviews, after their defense interviews, that it came to light that their information came, well, one specifically came from Dateline, and then they called each other and their information came from each other. So
I guess I'm working a little bit in the dark. What information is that?
Ooh.
whatever they're, I don't know, planning on testifying about.
Well,
None of them have personal knowledge of any kind of crime. So
the state's not saying they have personal knowledge of a crime. They have personal knowledge of things that may lead a jury to infer some sort of premeditation or motive. So what information is that? Let me ask the state. Or what's your offer of proof on why they're relevant?
With regards to Christina Atwood, she is a person who was present when the defendant was speaking.
I have to point something out real quick. So look at the two ladies right there. So on the left, that's the prosecutor who's speaking right now. And so she's the one that has like the strawberry blondish hair color. She's also the one who Lori tried to get disbarred in her motion to dismiss. That was freaking hilarious. Funniest thing I've ever read. But look at the comparison to her hair and the girl's hair on the right. I just wanted to say the girl on the right, that's what you call a really, really ashy blonde, a cool ashy blonde. That's like a 9T, the level 9 titanium. And when you look at the coloring, it's just someone did a really good job on her hairs, which is why I'm pointing out. When you look at the coloring of the way it fades from the roots into the part that's lightened, that is somebody did a really good job with that, because what's going to happen is that's going to grow really naturally. Anyway, I just appreciate it. It looks good. And also you can see a stark contrast there, right? In the warmth versus the cool. Obviously, there's other differences in color too, because on the left, it's like all one color pretty much. But someone did a really good job on her. I would say that's a foliage technique there on the right.
About the victim being possessed, which goes to, again, the motive of this, as well as the premeditation, and that those statements were made months in advance of the actual murder. With regards to Nancy.
So that's going to be offered as some form of admission from the defendant.
So that would be admission by party opponent, and that's personal knowledge.
Did you say that was Nancy Jo Hancock?
So that was Christina Atwood.
Yeah, we can talk more about those roots, can't we? I would say at the roots, Yeah, I would go with 7. I would go with 7 at the roots for the girl on the right. I'll go with 7 at the roots. Love that Meg knows what I'm talking about, though. That's pretty cool. I think I would also say there's probably some shades EQ involved.
Joe Hancock is the last person that saw the victim alive prior to that. What she knew about this was hearsay, but her statements to the victim of what he should do were her understanding and expression to the victim that he should tell the defendant that he had changed the life insurance policy to stop all of this from going on. So she both sees him the night before, is aware that he's there, and then she makes statements to him regarding what he should do.
Okay. And then
Kay Woodcock is the person who actually obtained the life insurance policy, which the state is alleging is part of the motive. And she also has information relating to the victim himself. There are allegations again of the self-defense, the use of a baseball bat, so she can provide background on the victim in that area as well.
all right. Do you want to have further argument?
Just the fact that this information that is supposed to be coming forward is not. All these witnesses are getting together and talking about all this and comparing all their notes and all these things beforehand. And then they're telling us that in these interviews. Well, I talked to her 100 times. Well, I talked to her every day. Well, she told me this. Well, she told me that. So their information is not firsthand. These witnesses are all coming together. They're all watching everything that goes on TV regarding this. And I would like them all precluded.
Okay, well, you're always allowed to cross-examine a witness about any biases they may have about those things that you've just talked about, colluding with other witnesses. Those are all areas of ripe for cross-examination, but they're not bases to preclude a witness. The court finds that based on the state's avowal that those 3 specific witnesses do have some minimal, although very limited, relevant information to provide and could be helpful to the jury in understanding the case. So the court will deny the motion to exclude the state's witnesses. Again, this ruling doesn't preclude you from any objections you may have to if they're testifying to hearsay or something like that. Next I have, is there a Mr. Eaton here appearing?
This is amazing. He doesn't know who Nate Eaton is. Meg, that's awesome. I'll go look and tell you what shades EQ I happen to have on hand. What about your blonde though? What do you happen to know what shades is on there for your, I mean, assuming that it is as it looks in the picture? Kane is rolling. What's wrong with you, Kane?
Your Honor, Matthew Kelly, I represent Mr. Eaton.
Okay, you filed a motion over the weekend.
Yeah, so the judge doesn't know
Mr. Eaton or someone that he works with filed a motion. Mr. Eaton was, let's address that now while we have people here. Mr. Eaton was
another time you're watching a hearing or a trial and there was somebody with a crazy braid. What was that?
Listed as a witness by the defendant. Mr. Eaton apparently is a reporter in Idaho and based on the filings believes he doesn't have any relevant information and shouldn't be listed as a witness. So let me ask the defendant, what relevant information would Mr. Eaton have? Why is he listed as a witness?
Well, I just got this last night, so I haven't had time to read all the things that he's claiming he doesn't. But there's several things off the top of my head that is relevant. Right now, one of the things is it's different now, right? Because he's had this off the record conversation with the prosecutor and he's kind of made himself a witness. He's kind of made her a witness.
How so?
In the sense that if this is not prosecutorial misconduct, then one of them is going to have to testify and talk about how it's not.
Let's back up. How is he a witness to this trial? How does he have relevant information?
Right.
Relevant information means a witness has testimony that makes some fact in the case more or less likely. So how does he have relevant information for what this
Although he has to redefine what relevant is for her.
case is about.
Okay, so initially when I put him on my witness list,
She's like, okay. She's like, okay. You see, she's funny. It's like defensive, right? He's just trying to help her so she can actually argue this. But anyway,
my intent is because I do not know what the state is going to put on in their case in chief. And so I was calling him as a witness for the purpose of impeachment, laying foundation for interviews, rebuttal to whatever that the state might put forth, because he has interviewed almost every single witness on their witness list. And if they were to say something contrary to what they said to him on a public thing, then I would use him to lay a foundation for interviews and for impeachment. So that was my initial, in calling him. I found it funny when I read the beginning of this. He says that it seems to be clear attempt by Mrs. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. So I had to laugh at that because it hadn't even occurred to me that he wouldn't be able to be in the courtroom if he was a witness according to 615. So that wasn't my intention. It was never my intention to do that. It was just to have him on hand if we needed to do that.
All right. Mr. Kelly, right?
Yes, Your Honor.
Mr. Kelly, in theory, it sounds like if a witness said something different than they reported to Mr. Eaton at some point, I guess in theory, she's right that Mr. Kelly could be called as a witness to impeach someone, but that's only allowed after the person's confronted with the actual statement that was made, and if they then deny that statement that was made. Do you have copies of his interviews and transcripts of interviews that you might want to impeach someone with?
I've been watching most of the interviews and I take my own notes, so yes.
Go ahead.
Your Honor.
She's never going to miss a chance to try to compliment herself. I've been watching most of the interviews and I take my own notes. Well, he asked if you have transcripts, so that's not the same thing, Lori. Your own notes are not the same thing, Lori.
Two things. One, excluding Mr. Eaton under Rule 615 would be a violation of his rights under the First Amendment to attend and report on this very public trial. But more importantly, Your Honor, if Mr. Eaton were to be called as a witness, the party calling him would have to comply with ARS 12-2214, which has very stringent requirements for subpoenaing and compelling the testimony of a journalist about information that journalist has obtained in the course of news gathering. As we state in our motion, we don't believe that there is any way that Ms. Daybell can meet those requirements. But I would suggest that if she wants to call him as a witness, she would absolutely have to follow the requirements of the subpoena law, and we would then have an opportunity to challenge that. But we don't believe that there should be any reason for Mr. Eaton to be excluded from the courtroom.
All right. I'm just thinking through this problem. If a witness got on the witness stand and said something different in testimony than you saw on an interview with Mr. Eaton, you would then play that interview. You wouldn't even need Mr. Eaton to do the impeachment because you could impeach them with the interview by playing it for them in court or something like that. So now that I'm kind of thinking it through a little more, I'm not sure.
And I wouldn't need him to lay that foundation for the interview?
I'm really trying not to give you any legal advice because you are acting as your own attorney, but if the witness admits that's them on the interview and that's their statement, that is foundation. So
he's interviewed law enforcement, almost all the law enforcement that's going to be, up here on the stand. So it's not just witnesses, it's law enforcement.
Well, when I say witness, I mean generally any witness, regardless of their occupation. So I don't foresee, I see it in only the narrowest of situations where he could even be called to as an extrinsic person to testify about the impeachment. You'd have to jump through a number of hoops before that as far as presenting the witness.
Jump through hoops like Gabby, our hero. You can be our hero, Gabby. You can jump through all the hoops.
What the statement is, and depending on whether they admit or deny that it's them on that video or interview or whatever the case may be that you're referring to. But I'm inclined to strike him as a witness at this time, allow him to be present if he so chooses in the trial. But then again, if you wanted him as a witness, you would need to subpoena him. But at this point, I'm going to strike him from the witness list and permit him to be in the courtroom. If there's a situation where you think something has happened during the trial where you think he should be called as a witness, I guess we'll cross that bridge when and if it comes. Okay.
We could just call him up from the back.
Well, we'll address it when and if it comes. Yeah.
And Your Honor, I would ask that if
Lori.
that were to occur, that I would be notified and given a chance to appear and be heard.
Well, everyone will get a chance to be heard if we cross that bridge. I just don't see us crossing that bridge, but I could be wrong. So at this time, it's sort of striking Nate Eaton from the witness list. He can be
Yay.
present if he so chooses in the courtroom.
You will be.
Thank you, Your Honor.
Well,
Right,
bet
thank
your
you.
bottom dollar, Judge.
Let's go next to the state's motion to preclude media from displaying or disclosing phone numbers and email for witnesses and victims. I guess I have no problem granting this in concept, but let me ask the state: are these people going to testify? This is my phone number, or this is my email, or it's going to be displayed up as part of the evidence on the screen, or both?
Yeah,
Phones that are on text messages, email.
we don't need people's phone numbers. Hopefully that shouldn't be a problem. They're usually redacted in trials. Right, being live streamed, correct. Let's not dox anybody. Yeah, bleep it out, silence it. Yep. Okay, now we have the state's motion to preclude. So now this is the one precluding Lori's defense expert, because remember how just recently, just like the other day, she was like, oh, I want to do celebrate extraction of all these things last minute. And it's like, okay, Lori, read on.
Let's go to state's motion to preclude Lonnie Dorkin and preclude noticed witnesses.
I know
Did Mr.
nothing
Dorkin
about
ever get a
hair
report prepared?
Not that the state has received.
He's got his glasses, guys.
Do you know?
Oh, look at her go. Look at her whole outfit. She's ditched the her previous look. Yeah, I like this judge.
So, okay. Your Honor, most likely, we're having an affidavit sent over from Mr. Dworkin tonight. He has found a discrepancy in the information that he downloaded and the information that was turned over initially by the state, and he wants to explain what that is and how that will be relevant.
Yeah, right. There's no way he's done a celebrate report in like 2 days.
So if we did it tonight, we'll forward it immediately
Lori?
to the state, of course, tonight. He was working on a bunch of cases and he's doing the best he could to include
You
our
wanna
case and
turn
get it
that
done as
over
quickly
right
as
now.
possible as when he was assigned from OPDS.
Well,
Oh dear.
at this time, I'm inclined to preclude Mr. Dworkin. Granted, something pretty extraordinary happening. I offered you a continuance last time.
Something extraordinary, like Gabby jumping through all the hoops and doing the teeter-totter. Thank you again for the super sticker, super chat. Is this a hair gel? Question.
We were in court in order for you to explore that possibility. You declined the continuance. So it's any disclosures late at this point. I'm not going to slam the door on it completely because he may or may not have anything that actually ends up being useful. But at this, depending on what he actually has, we can talk about it. But at this time, he's likely to be precluded as a witness because the state wouldn't even have an opportunity to have their own witness or rebuttal witness look at something prior to trial. But again, depending on what you have, we can talk about it again.
Okay.
The rest of your witnesses, we've already talked about Nate Eaton. I don't know if we need to go through each and every witness, but I think where I need to start is if a witness hasn't been served with a subpoena to appear in court, there's no requirement for them to show up for your trial. If they have been served, they would need to submit to an interview with the state in advance of their testimony. And then the third aspect is they need to have something relevant
Relevancy.
to testify about, which relevant, I
Yes,
told
we
you
know.
a little bit ago,
Uh-huh.
means they have a testimony that's not based on hearsay, that tends to make either a fact more likely or not. So Why don't we go through, I'm trying to compare your witness list to the state's motion. Let me see here. So Nate Eaton, as of now, is not a witness. Next, we have, I don't know how to pronounce her name. Is it Viasia?
Vicia.
Vicia?
Idaho.
Oh my God.
Is this one of the ones the state was able to get a hold of?
No, Your Honor, we did
So
call.
remember, part of the issue here is that Lori's got these people on her witness list that the state can't get. They can't get in touch with them. They can't find them. They can't get addresses or phone numbers. They can't even get in touch with these people. And apparently, as we will hear more about, Lori's own defense, like, investigator, right? Like, can't even get a hold of them either. Which, sorry, had to sneeze. We have pollen going crazy right now. Which might mean that these people don't want to testify for Lori. And you know what? You can't blame them, right?
The numbers and left voicemail, I've not had any response. And it's my understanding that when I interviewed the defendant's investigator, Jeff White, he also was unable to speak with her.
All right. What about Gabriel Bonilla?
Your Honor, I had an update on that one in the sense that on Saturday, so when the state interviewed, again, Jeff White, the defendant's investigator, he had not been able to speak with Mr. Bonilla. I also called and left a message on the phone number that I received from the investigator. On Saturday, the attorney for Mr. Bonilla called me, and Matthew Ballard, who represents the Church of Latter-day Saints. He advised me that Mr. Bonilla has not been served with a subpoena, but I did not speak with Mr. Bonilla or was not given an option to speak with him.
So we don't know if that person's been served or if they have relevant information.
According to the attorney, Matthew Ballard, he has not been served.
So what I want to know, maybe we'll learn this, who is on Lori's witness list that has been served and is testifying? Like, so far, all I know at this juncture and that we've heard about is she can't get a hold of anybody. Like, you know, people on the witness list, but so far none of them are showing up. So
What about, well, why don't I just ask the state? I've got your supplemental and your other one. I know you've actually talked to a few of these people on the phone.
Correct.
Is there anyone on this list, and I'm looking at the defendant's supplemental 15.2 filed March 12 on page 2, there's a number of witnesses listed out. Is there any on this list that you have talked to that you don't object to being called?
Your Honor, I think that there is potentially minimal relevance from Summer Shiflett.
Chislett?
I think that's a misspelling
Oh.
of her sister's name.
Okay.
yeah, Summer Shiflett is one of Lori's sisters.
I think there's potentially minimal relevance for Janice Cox, her
Sure.
mother.
Okay.
Okay, so her family, Lori's.
Adam Cox is actually on the state's witness list, so we don't object to him.
Is Lori going to call Adam? I really hope not. That would be brutal.
I did speak with Zachary Cox. I'm not aware of any relevance as to this case from him, but I did speak with him.
I see in your pleading that he advised you he's not been subpoenaed.
Correct. Everyone I've spoken with has not been subpoenaed.
All right.
Your Honor, our subpoenas are with OPDS right now, and they should be being issued currently. The state talks about in their response, like the state is claiming trial by ambush from the defense. Trial by ambush. How is the defense trial by ambush when they have interviewed every single one of these witnesses before in the last 5 years since this case started? They've interviewed every single person that has been on there. They have written, transcripted interviews and video interviews of all of these people. And so how they are relevant, these witnesses will testify if and when they are needed to add additional facts or fill in the blanks that the state will no doubt leave out in their case in chief, and they'll be called accordingly. I need them to lay perhaps foundations for evidence presented by the state. The same with Lonnie Dorkin. I need his testimony will be required if and when it's necessary to rebut digital information that the state will bring forward during trial. I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not going to let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
All right. Well, that's
Oh dear. I have some thoughts too on Lori with the speedy trial thing, but we'll talk about that here shortly. Because I think it comes up again. That is the have a nice day is a bit extra.
And so how they are relevant, these witnesses will testify if and when they are needed to add additional facts or fill in the blanks that the state will no doubt leave out in their case in chief, and they'll be called accordingly. I need them to lay perhaps foundations for evidence presented by the state. The same with Lonnie Dorkin. I need his testimony will be required if and when it's necessary to rebut digital information that the state will bring forward during trial. I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not going to let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
all right. Well, that's why attorneys sometimes take a long time to prepare for a trial, because they need to give notice of what all the testimony their witnesses are going to give. They need their experts to prepare reports. That's why your prior attorneys and your current attorneys were asking for more time to prepare the case. So you can't really have it both ways, that you want your speedy trial rights, but you don't want to give notice to the other side of what your evidence is.
I don't not want to give notice to the other side, with the limitations at the incarcerated state where I am, and the limitations with OPDS of getting Lonnie Dorkin late in the game that they did. I've done everything in my power as a defendant to prepare the state and to give over everything that I could do within my power, with the limitations that I am an incarcerated person at this maximum security prison jail.
So when you say,
And I shouldn't be able to represent myself because of that fact, that negates my constitutional right.
I didn't say that. All right. I said that sometimes there are reasons to not go forward to trial as fast as you want. All right. So when you say things like they're going to fill in the blanks, that makes it really hard to assess what their relevant information is.
They have relevant information to a lot of factors that I got in the 404B information.
Yeah, I know.
For example, the life insurance. My father is a life insurance salesman. He worked with Charles on getting both life insurance policies, my $2 million policy and Charles' $1 million policy. He also tried to sell my insurance policy after Charles passed away. He also told me to go to call the insurance policy and said how to do that, how to call them when you're the beneficiary. I didn't know how to do any of those things. He has relevant information to that. My sister has relevant information to my brother, Alex Cox, and the whole situation of what happened on July 11th. These people have relevant information to the state's case, what they're accusing me of. There's very relevant information from a lot of these witnesses.
So what I'm struggling with is you just saying that it's relevant doesn't actually make it relevant. It may be relevant. I'm trying to find out the relevancy. What you said about your father being an insurance salesman and selling policies, that sounds relevant. It could be relevant to me. Who's your father? I don't know who your father is.
Barry Cox.
All right, Barry Cox. It sounds like even from what you're saying, though, you're not, depending on what the state produces at trial, you're not sure that these witnesses would have relevant information. It just depends, is what it sounds like.
Whatever they put up in their case in chief, am I not allowed to
Oh dear, Lori,
try to defend myself against that?
No,
You're absolutely allowed. I'm just trying to figure out, I'm sort of a gatekeeper, and I need to make sure witnesses have relevant information. And just like you have the right to interview
She
all
doesn't
of
know
the
how to
state's
argue it.
witnesses excluded.
She doesn't know how to argue it. That's why she's saying that, because she's trying to swap it. She's like, aren't I allowed to put on a case? Yeah, you are. He's trying to help you, Lori. The way you put on a case, right, is you bring in witnesses that have relevant evidence. He's trying to help you do that. You have to say what they have testified to that's relevant. And instead of answering that question, she's like, aren't I allowed to put on a case? God, it's just, I know,
Even
Meg.
victims' rights, people that could deny having an interview, they have the right to interview all your witnesses prior to trial, so they can have an idea of what those witnesses might say on the witness stand.
I understand that, Your Honor.
So
They also have already interviewed
I do
all of
also agree. While she is really annoying, she is still nowhere near the level of books. They are different categories of pro se defendants, in my opinion.
I'm not talking about police interviews or interviews that may have been done years ago. The prosecutor has the right to interview any witness prior to them taking the stand, just as you do. So I'm not sure the best way to handle this, other than maybe we should take it up as we progress through the case, but
Your
some
Honor,
of these people may or may not be even served.
yeah, my concern is obviously I have attempted to reach these people. I've made my good faith effort. I've been told both by myself in attempting to contact them, as well as the defense investigator, that they've been unable to reach them. So it seems to not be following the rules of procedure or evidence to then bring up later on if they perhaps find these people at some point. Then the state can try to, at that point, preclude them. When the state talks about a trial by ambush, it is in fact that. When the defense investigator themselves cannot find these people and are still looking for them in trial when they've had at least, we'll say, 4 months to try to find them, I think that at this point, precluding them is proper.
Well, I would preclude anyone that doesn't submit to an interview with the state. I kind of want to punt this a little bit just because if there's people that don't end up getting served, don't end up showing up at court, they can't find, then we don't need to waste our time talking about whether or not those people have relevant information because they're not going to be here and they're not going to testify. So I'm putting the defendant on notice that if these witnesses aren't served, if they don't submit to interviews, they're going to be precluded. Even if they submit to interviews, I may have to make a determination whether their testimony is relevant or not. So again, we're going to, I think, have to cross that bridge when it comes. The state did say that they concede that some of the witnesses, Adam Cox, Janice Cox, Summer Shiflett, may have some minimally relevant information. The rest of these, I think we're gonna have to take up maybe on a piecemeal basis, but I don't want it. It's not gonna be a situation where you're ready to call them in as a witness the morning of, and then the state they haven't been presented to the state for an interview prior to that. So keep that in mind when coordinating with your investigator. If he gets them served and they're actually gonna be called at trial, they need to submit to an interview in advance of their testimony.
Your Honor, I understand that. And I am limited in what I can do. If I could call these people myself, they would answer my call probably, and I could have this discussion with them. But I'm going through the limitations that I have at the jail through my paralegal who's working overtime and my investigator who's working overtime to try to do everything to help me prepare for trial, as they have other clients as well that they have to do things in a timely manner for. So we are doing the best that we can.
Okay. All right. We next have defendant's motion to dismiss for violation of confidential communication in the 6th Amendment dated March 18 of 2025 and the state's response. Let me ask the defendant first if you've received the state's response.
I did.
Did you say you did or didn't?
I did.
Okay.
Yes.
If you have an attorney in Idaho that is working on an appeal, it appears that the information that was turned over by the jail was some pretty innocuous messages about trying to set up the legal line to talk to you on a confidential line. And really that's about it. So how does this arise to some sort of nefarious interception of things? Because it was put on a public chat system that the jail uses. You know it's not confidential. And you're told it's not confidential. And then even if I look at the substance of the messages, there's really nothing in the messages that would arise to some sort of confidential communication, just trying to set up a meeting and get the unrecorded legal line set up.
Who's saying that they're not confidential?
Well, the
Who's
jail,
telling me that they're not confidential?
your own attorney, it looks like. Here's a message. I see that they came and got you. I'm working on getting a confidential attorney line set up. The implication being that this message is not confidential.
A lot of overlap here, right, guys?
The next one.
Other cases such as Shannon Gardner, for example.
Again, just checking in. Hope things are getting a little better for you. I'm still working on getting a legal line set up.
I mean, completely different. Just overlap, maybe, potentially. Lori is alleging that there's been, attorney-client privilege information that's been, I guess, viewed or potentially viewed by the prosecution. Completely different than, well, Shannon Gardner went a step further because it was also disseminated multiple times over, and it was actually like evidence discovery in the case. So
The implication is that these are not confidential.
Okay, so then he received a letter from MCSO that said, your phone number is now confidential and arranged for privileged confidential client privilege communications. So
Phone
from
calls.
my no, it says this phone number is connected to that. So from my perspective, when I call someone on the tablet or when I text someone on the tablet, it goes to their phone number. So all the communications after the date of the exhibit that we put in our motion, when he got that letter from MCSO that now all of your things will be confidential.
The thing about the way that she sounds like she's just got an attitude this whole day. Previously, she didn't sound quite as snarky, and the attitude, the problem that I have with this is that it's with the judge, right? Like, I think you need to be careful. It's because you don't, especially, when the jury's there, right? You don't want to, not that she knows this. I'm just going to fall on deaf ears, this advice, right? Lori, don't be an idiot, right? Well, too late for that. So
Confidential. Now they will be confidential. So my understanding, and I'm the only one that can waive that privilege, right?
And I think after that, when his line was approved, there were no other disclosures of messages between you and him, correct?
No, there are.
You received other disclosures of intercepting messages between you and him?
So those go up to the 24th of January?
No, the only thing I saw was up to, I think, late December of 23.
Okay, so there are confidential things that are in our communications because I was not aware that after he received that there were not. So the prosecutor who obtained these, her protocol would not be to stop and ask the court for some guidance on this, maybe do an in-camera review if she's subjecting herself to client privileged communications instead of reading them. And
so there, I will say, I'm impressed that she knows what in-camera means. James, that's very insightful. Saying she's in, now that she's in street clothing, that's why she's this way. You know what? I think you're absolutely right. That makes a lot of sense. That her persona would be different because now she's playing attorney. That makes a lot of sense.
Things that are in our communications because I was not aware that after he received that there were not. So the prosecutor who obtained these, her protocol would not be to stop and ask the court for some guidance on this, maybe do an in-camera review if she's subjecting herself to client privileged communications instead of reading them and finding out and assessing for herself if there are anything in there that's confidential information between me and my appeals attorney. I have no other way to communicate with him when I'm in this incarcerated situation because I was brought here to Arizona to deal with these charges.
In this incarcerated situation, Lori, you've already been convicted of killing 3 people.
So
what situation do you expect to be in?
It is a problem. It's a problem that she took them. It's a problem that she got them from MCSO. It's a problem that she read through them. It's a huge problem that she put some of them into her motion and now his IP address is exposed to the public, which is a federal offense. There's a lot of things wrong with what has happened here.
Well, you reminded me that when his number was approved, he then sent messages from different IP addresses instead of that phone number that was privileged. So he's the one that disclosed or violated the confidential nature. I don't see that any of these, I'm going to call them inadvertently intercepted messages between you and your appeal attorney. I don't see that they're being used in any way by the state.
Just the state reading them as a violation of the client attorney privilege.
Well, not if they're not done through a privileged setup the way that they were supposed to, which he even acknowledged.
My understanding from my perspective was that phone number was now privileged. The way it comes to me on the tablet is I text that phone number or I call that phone number.
Correct.
So,
if you're communicating through the phone number, but if he has it set up where the messages aren't being sent and received actually through the phone number, but through different IP addresses, the system doesn't know that they're privileged because they're not being sent and received through that privileged number.
But I didn't know that. There's no way for me to know that from where I am in my cell. There's no understanding for that. I assumed he was just getting them on his same phone that we were having client attorney privileged communications. And is the state giving these to Idaho? Do these get dispersed out? I would like to know that. Where are these going? They're getting them from MCSO. Is there a subpoena to get these from MCSO? Is there a warrant to get these from MCSO? I didn't see anything that warrants them getting them from MCSO in the first place.
All right, let me hear from the state.
And I think that the state's motion really covers the law under this. The defendant and her attorney were provided with information, whether or not she understood it or not. Her attorney understood that it was phone calls that were covered. So it's not just the defendant who is not complying with following the correct procedure to utilize the set up attorney-client privilege means to communicate. In this case, the state, obviously, I disclose those before I even look at them. I understand that they are statements by a defendant, and I believe that they are to be disclosed under Rule 15. And so before I even look at them, I send them to the defendant because I don't have the option of not providing them to her since they have been obtained. I think if you apply the case law in this, the defendant cannot meet her burden to show that there's any legal advice in these messages. There's no privilege in them. The messages are asking to set up times to call and to speak.
Kane.
Are the three, I think it's 3 messages that you included in your response, are those all the messages?
No, Your Honor, there are other messages, and we do say the tablet messages between Ms. Daybell and Mr. Jerem do not end on December 28th. They continue.
And there is privileged information on them going forward. And the state is basically testifying for my attorney now. She just testified for my attorney.
I just have to say, I'm still loving that hair color on the right. That is just really well done. Really, really well done. Somebody did a phenomenal job with that color. I wish we could see all of it. Maybe we will at trial. Like, will the lady on the right please stand up? Please stand up. Sorry.
That he understood that they were that these were not privileged communications. Where does she understand that where is she testifying for my attorney?
Well, I think because of the context of the messages
We
say,
still don't know how she did her hair in prison.
I'm trying to schedule a time and I'm trying to set up a confidential line, meaning
That was
this is not
before.
confidential.
That's right. He said it wasn't confidential before MCSO gave him a letter saying your phone number is now confidential. Your phone number now has.
Okay, I'm not going to keep rehashing this with you. The fact that he's using different IP addresses and not messaging through the actual phone number that's protected, I think is part of the problem. So if he's not using the program correctly, that's an issue you need to take up with your attorney.
How is he using it incorrectly?
I just told you. He's not messaging through the phone number. He's using different
I just told you.
IP
How
addresses.
can you message other than the phone number? I don't understand that.
I don't understand that either. But if it was from the phone number and it's for his cell phone, for example, it would be the same IP address for each communication. There's like 4 or 5 IP addresses.
Where are the IP addresses coming from? They're given to you by the state?
They're right there listed on the messages.
I'm just saying, where are they obtaining those from?
God.
From your attorney's messages to you?
From MCSO?
Yeah.
Did they get IP addresses for every single person of every single message communication on the text from MCSO?
Well, it's listed on the messages, so I assume so. It says Craig Durham, and then under it is IP address from the device that's being used.
He's like, I'm just reading it. It's right here. And so what you notice too is she's just arguing. She's not looking at the actual messages. So he's got him. So she should, right? She should be looking at the messages so she can see what he's talking about. And then she could maybe make another argument or whatever, or concede defeat. But instead she's just arguing and he's looking at it. So,
Okay. And then,
you know,
Ms. K is reading all of these messages and they're not privileged. Is that what you're coming to?
They're not privileged if you're not using the program or your attorney's not using the program correctly. Okay, they're still not going to be allowed to use any of these messages. What I'm saying is they're inadvertent disclosure by MCSO because someone's not using the program correctly doesn't mean that they had bad faith in how they got them. They made
How is he using it incorrectly?
I don't know how else to explain it to you. I've told you 5 different times now. So
oh my God.
he's not messaging with the phone number. He's messaging from different IP addresses.
Okay. Can I ask if these?
That is amazing. By the way, Meg, I just looked at my collection there for Shades EQ. I've got 10N, 9N, 8N, and 00 clear.
How is he using it incorrectly?
I don't know how else to explain it to you. I've told you 5 different times now. So he's not messaging with the phone number. He's messaging from different IP addresses.
Okay. Can I ask if these messages are being disseminated anywhere to Idaho, to the prosecutors in Idaho? Because that's definitely affecting my appeal if that's the case.
I don't know.
Not been sent to anyone other than the defendant, Your Honor.
All right. So there was some communications I find that were intercepted between Ms. Daybell and her attorney. The state's not to use those communications. They're not to disseminate those communications, but I do find that they were.
Do you guys think it's a coincidence that now for this trial she's dropped the Vallow part? You know, considering it's Charles Vallow. Now she's just Lori Daybell. Pretty funny, huh?
Purposely sought out by the state.
MCAT, woo!
And that dismissal isn't the appropriate sanction if there is an appropriate sanction. It's ordered denying the motion to dismiss for violation of confidential communication. All right, then we have defendant's motion to dismiss for prosecutorial misconduct dated March 21st. Let me get that. And the state's response. The motion to dismiss for prosecutorial misconduct was filed on March 21. The response.
You guys all see that? Because that was the funniest thing I've ever
I do
seen.
have the response. Did you get that response? Ms. Daybell, did you get that response?
I did, Your Honor.
All right. So your prior attorneys had, actually, let me back up. The state filed a motion back in, I think it was September of 2024, asking the court to preclude your defense team at the time from making public records requests through Gilbert and/or Chandler police departments. I denied the state's request, saying that the defense is free to do their investigation and make public records requests through appropriate means. So that's part of your complaint.
By the
that
way,
they didn't provide those public documents to the defense.
By the way, for those of you guys who were here for our Twin Flames, I don't even know, 8-hour incredible, jaunt, if you will, into insanity with all that. I know I've mentioned before that I'm putting together a compilation best of video. If you guys were there, it will probably not surprise you that the best of compilation that I'm putting together is pretty substantial in length. Oh, that's what she said. Because it's all so good. And some of it is y'all's comments that were just killing me. And anyway, but I'm pretty close to being done. I think what I might do is make it a members only, because all of that is available, of course, on the live streams, but I think I might make it a members only because I think it might be a good idea. I could, I haven't had any issues with the YouTube, for cursing or anything like that. Cause I know there's some people that say you're not supposed to curse. I don't know. I've never had any issues. So I don't know. Or, speaking about things that are, sometimes we get a little bit, what did you call it? X-rated, as it were. I don't know what to call it, but anyway, as I've been editing these videos, right, or this compilation video, I've realized that if ever anything that I've live streamed could potentially cross a line, maybe in YouTube's view, probably it would be that. And I mean, to me, that's a good thing, right? And it's it's just between the comments and my comments, y'all's comments, and what they're saying, it's they say the word grape without the G a bunch of times. I mean, it's all of the things. So I'm thinking I might make it a members only. But also the other reason I might do that is because it's not it's not what I typically do, right? Because it's kind of a branch off. It's not trial related. It's just craziness. So anyway, but that's might be what I do. But I have that almost done. But I'm glad we don't offend Flash with our cursing. Oh, it won't? Okay. I do think, though, it'll be you know, because a lot of times, and this is sort of what I think, you know, a lot of times, like with channels of like members only stuff, it's stuff that is not the typical fare, right? So for example, like that's why, you know, for example, like the orchid videos as an example, right? Or, you know, obviously we've had the games and stuff. But that was the other reason why I was thinking members only, because I feel like, because I already have it in 2 different streams where we have, where we were watching those Twin Flames videos, and it's kind of not, you know, because there's some channels I think that exist that only do like deep dives on cult stuff. I mean, I don't know, I would imagine. Anyway, so I don't know. That's the other reason too why I think it might be better to have it members only, just because, you know, I already have a variety with like between the law stuff and then the music stuff. So Lori's trying to make you a sinner. I think so. So when is trivia night? Good question. So I'm thinking I might do it this weekend, and here's why. Because there's so much going on with these. Well, so Lori's trial is going to be starting tomorrow. They have a jury. Her trial is going to be starting tomorrow, right? And then we've got yeah, okay. I think I'm going to make it this weekend, because over the weekend we get a break from trial / pre-trial onslaught, right? Good night, MCAT. Happy to see you again. So yeah, it'll probably be this weekend. And that reminds me, thank you for mentioning this, James. If you haven't gotten your categories in, now's your chance. And yeah, it'll probably be, we might make it Saturday night. Oh, opening start on Monday. Okay, thank you, Flash. Thank you. I didn't know that. Okay. Well then, I would probably say this weekend, just to be safe, because that's good to know that her opening statements don't start tomorrow. However, there's still so much going on in the other cases, right? With Karen Reed and everything else, BK, there's going to be more stuff. So I think Saturday would probably be a good bet. I think, did you mean to say EDB? Yeah, weekends. I don't know who Sean Grayson is, Flash. Yeah, it's all good. Happy any. Yeah. So, you know, I'm not, you know, I curse in like every live stream for the most part, probably. But the subject matter, in addition to the cursing, would also be, it's just, you know, it's good. So, anywho, so yeah, I think probably Saturday. Now we might do the Twin Flames one. We might do that earlier, because, as soon as I get that compilation done, we're going to want to watch that. We'll probably do it more than once. It's going to be so good, you guys. It's going to be so fucking good. Even just putting it together, I'm yet again laughing so much that I'm like hurting. Like my face is hurting. I'm laughing and crying at the same time. Earlier today, I spewed water everywhere because I just like pressed play so I could continue to edit this. And I didn't even know where it was going to pick up. And then it was just wherever it was. And it was just like already anyway, it's just so funny. It's so good. So good. I don't think so, Flash. I don't think I asked you about that case. James is learning the violin. Do you have a violin? Do you have a teacher?
That's sort of a civil issue, I guess, but let me hear your argument on that.
That isn't really the complaint itself.
That's your first paragraph.
I know, but the complaint is that.
I'd like to take each allegation and deal with them one at a time.
I understand that. My complaint is the interference by the state, Ms. K in particular, in stopping that and interfering with us trying to investigate and do our own investigation. It is a violation of the constitutional right and due process. And she did do it, and she did do it purposefully. And then after she did it, and we weren't allowed to have anything from either of the police departments, then she filed her motion. And then later, the day that I was Rule 11, that is the day after when you said that you denied that
Rule-
motion.
Rule
So
11 is the.
I don't know what she did or what she said to Chandler and Gilbert to stop them from giving us any information. But as soon as we put in a request, we were cut off. No information. You can't have anything. That's when I was trying to, the big video that we're trying to get in Gilbert, that's what I was trying to request. I tried to request that myself because I would have my investigator to go and explain what that was and why we didn't have it. And so we were precluded from doing all those things by the state. They should not be interfering with that. That's one of the reasons why everything has taken so long. We haven't been given things we've asked the state for. We haven't been given them. We tried to get them from Chandler and Gilbert. We tried to get them from them. She's stopping us from getting
How long has it been taking?
from them. How are you supposed to put together a defense?
So when your prior defense counsel put in that request back in September,
Mhm.
the state says that they obtained those information and gave it to your attorneys on October 1. So why are we waiting until March to address this if you had an issue with that?
A valid question from
I
the.
have had an issue with it the whole time. I've
So
been
why
taught-
didn't you file why didn't someone file a motion back in
Oh,
after, December, November, January, February, saying they had an issue with this?
I did. These are in my motions to you for specific discovery. I discussed this exact problem.
Okay. Well, now you're saying it arises to prosecutorial misconduct.
It is.
This is the first I've been made aware of that, as far as I know, that the police department never honored the public records request. If they don't honor a public records request, there's a process to go through regarding that.
Which is what?
I'm not going to give you legal advice.
oh,
All right. Your second allegation, the prosecutorial misconduct, we've already kind of dealt with, that she distributed the state distributed attorney-client privileged communication. We've discussed that. The next one is legal advice to the defense witness, Nate Eaton. We've somewhat discussed that, but I think their motion, the state says that they simply notified him that he would need to be served with a subpoena to have to appear in court.
oh my God,
So how is that improper?
y'all. I just wanted to say, Kane's right. I just looked it up. He's right. Val Kilmer just died. He just died. Oh, wow. That's crazy. That happened. Wow. Okay.
It's taking
That's terrible.
It's taking her word for that that's what happened. She's not under oath saying that that's what happened. Nate Eaton's not here to testify that that's what happened. They're the only two parties that are there to say that that is what happened. So that is my problem with it. I would like for one of them to get on the stand and say exactly what happened in that conversation and that she wasn't giving him legal advice. How do we know that she wasn't? It's a very curious situation that he called her and then he writes in his motion this statement that obviously comes from Ms. K. She seems to be a clear attempt by Ms. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. We also don't know if he told her, don't come to the March 18th hearing because that's when they're going to serve you with your subpoena. So all these things come from there and we don't know who's saying it. And you're just taking her word for it. Like you took her word for, oh, there's only 6 emails and there's no other emails. You're just taking her word for it as an officer of the court. And I think that she should have to be sworn in.
Well, you want me to just take your word for he must have gotten these things from Ms. K. Okay. Just because his motion says he thinks that you're.
This is great. This y'all, listen to this. I love that he's calling out her bullshit.
To the March 18th hearing because that's when they're going to serve you with your subpoena. So all these things come from there and we don't know who's saying it. And you're just taking her word for it. Like you took her word for, oh, there's only 6 emails and there's no other emails. You're just taking her word for it as an officer of the court. And I think that she should have to be sworn in.
Well, you want me to just take your word for he must have gotten these things from Ms. K. Okay. Just because his motion says he thinks that you're noticing him as a witness to keep him out of the courtroom. I don't know why you take the jump to that is coming from Ms. K as opposed to his own volition. He also hired an attorney that said the same thing. Even if she had said you need to be served with a subpoena to have to show up in court, that is not an ethical violation.
Well, giving legal advice is an ethical violation. Is that correct?
Stating what the law is not an ethical violation. If she said, I don't think you should show up at court, even if you're subpoenaed or something like that, that could be an ethical violation, but we don't have that.
How do we know we don't have that? That's my question. How do we know what went on in that conversation if it wasn't recorded? Aren't witness?
You can interview
Interviews
him.
recorded?
You can interview Mr. Eaton. Your investigator can interview Mr. Eaton. So when and if you get that information from Mr. Eaton that something nefarious happened in that conversation, bring it up then. But you're jumping to conclusions. You have the right to interview any witness, okay?
Not a witness anymore because you just precluded him.
All right. You can interview him. You can have your investigator interview him.
So even though he's not a notice witness now, we can still interview him and try to find this information because we can't get it now? Is that what you're saying?
Sure. Have your investigator call him. Ask him about the conversation. At this time, I'm going to, based on just the pleadings, I'm denying the motion to dismiss for prosecutorial misconduct.
Of course.
All right, 609 motion.
I'll hear that. Hold on, let me back it up.
The state's alleged a total of 7 felony convictions.
We can still interview him and try to find this information because
He's got a
we
hot
can't get it now? Is that what you're saying?
Sure. Have your investigator call him. Ask him about the conversation. At this time, I'm going to, based on just the pleadings, I'm denying the motion to dismiss for prosecutorial misconduct.
Of course.
All right, 609 motion. The state's alleged a total of 7 felony convictions in the state of Idaho. Under Rule 609, the court finds that limiting the number of convictions and the nature of the convictions to be appropriate as to not be overly prejudicial. There is an interest in allowing a jury to know that the defendant's been convicted of at least 1 felony. But let me hear, I'm inclined to probably limit it to 2 felonies in order that they be sanitized. Does the state want to be heard on that?
Your Honor, I do believe that the court should allow for at least 3. There are multiple dates and multiple victims in those and multiple different distinct incidents. And I believe that it would be appropriate to, when we're talking about the credibility of the defendant, to allowing in 3 of those.
I looked at the date ranges and I looked at the actual counts, and some of the counts, obviously the laws are titled differently in Idaho, but there's a couple of counts that specifically have what I would call dishonesty built into the name of the conviction, the first-degree murder and grand theft by deception. Those are counts 1 and 3 specifically. And again, these only become relevant if the defendant chooses to testify. I did read the defendant's
You guys think she's going to
response asking that all of them be precluded.
I'm really curious. What do you guys think? Is she going to testify? Thank you so much again for the super sticker, James. That's right. Yes. And I would imagine her advisory council will mention something about that, you know, to her to make sure, you know, what you need to do is make sure you keep the mic off, right? And then turn it on to talk. That's why usually what happens is you'll hear attorneys forget to turn the mic on, you know, Elaine, your mic, for example, right? Because that's better than the other way around. But also put a 1 in the chat if you think Lori might take the stand in her own defense, or if you think she will. Whether she should or not, different question. But if you think she will.
Let me hear from the defendant.
One second, Your Honor. Your Honor, I haven't had a time to, I wasn't planning on talking about the 609 today, so I'll just refer to my reply.
Well, we can table it till later in the trial because again, it doesn't become relevant unless you choose to testify, but you know my inclination and what the state's argument is.
Okay.
This morning I handed each side proposed preliminary instructions. We don't need to discuss those now, but depending on tomorrow how far we get in the jury selection process, maybe you can be prepared to tell me if you object to any or if there are additions or corrections that need to be made. All right, I think that's going to be it for today, but let me check with the state. Is there anything else we need to address today?
So one, if you think she will take.
I think just for the record, Your Honor, in terms of allowing in witnesses, the gallery, I think that you had indicated you would reserve one row for the next of kin.
Yeah, let's discuss that. We're going to put up signage after we complete jury selection. So the first row on both sides behind defense counsel and behind the state will be reserved for immediate family members, next of kin, those sorts of people, relatives. The very last row on both sides will be reserved for media. And then the middle rows in between those two will be kind of a first come, first serve general public viewing area. Any questions about that?
I do just want to make sure that, assuming we're leaving on the defendant's mother, father, sister,
Well, if they're potential witnesses, they won't be in here.
the state will be invoking the rule of exclusion.
Do you understand that, Ms. Daybell?
I do.
All right. So as long as people that we haven't already addressed other than Mr. Eaton remain on the witness list, the rule of exclusion would be in fact, it means that they won't be allowed in the courtroom except for your investigator can be in the courtroom. And they're precluded from talking to anyone about their testimony or other testimony until they're released as witnesses. Anything else from the state for today?
I don't believe so, Your Honor.
All right. Anything from the defense for today?
A couple of things, Your Honor. We need to discuss
how the division would like the media exhibits.
What?
How the division would like the media exhibits, if we're presenting recordings or audio, individual flash drives for each exhibit. There wasn't.
Depends on how you're going to present them, but I would say, yeah, probably one flash drive per recording or exhibit.
And then I'm guessing 3 copies, one for state, one for.
I don't know that you need copies if you've already disclosed it to them. Just tell them what it is when we're marking it and tell the clerk what it is with the description so it's clear on the exhibit list which exhibit is what.
one more thing, Your Honor. I wanted a clarification in your minute entry dated the 25th regarding the defendant's motion to remove restraints. So my understanding when I read what was from MCSO, and then you put in here, however, at the sheriff's discretion, one or more armed sheriff deputies may be positioned near the exits. So what their recommendation was the minimum amount of restraints, meaning if there was going to be an armed guard, then they would not have to do the belt. So I was confused by and wanted a clarification on what you were actually ordering because the DOs had a question about it with me this morning. So
I ordered that you don't have to wear the leg restraint, but that you do have to wear the rack belt because that is not going to be visible to the jury. The leg restraint's a little more cumbersome and visible. And since you're representing yourself and you're going to need to approach the podium and those sorts of things, I ordered the removal of the leg restraint. You will, though, wear the rack belt. And then I said it's up to the sheriff.
If she misbehaves, they can shock her or whatever. You guys, I'm sure, are well aware of that. Yeah, they're allowed to speak. I mean, they haven't said a whole lot. I mean, you know, I don't really know how that works as far as the rules go. And well, in terms of in front of the jury, right? I mean, they've already set up parameters ahead of time, right? But I think in the hearings, right, they've not said a whole lot. They just are, I suppose, speaking up when I don't know, they just asked that one question about the exhibits, which is interesting. That's also interesting. She managed to get a jury mostly men. By the way, for anyone who didn't hear, for Karen Reed, I meant to say this earlier and I forgot, they did manage to seat one juror, or like one juror was confirmed out of the batch today. So they got one juror already. Twiz, where the fuck have you been? Twiz. Right. Anybody can represent themselves pro se. I mean, you know, you saw you were talking about Daryl Brooks earlier. Oh, I didn't see your text. I must have missed the notification. I was teaching. But what do you mean? Do you want me to text you when I'm going live? I mean, aren't you like, don't you get notifications through Discord and YouTube? They got 2? Oh, I saw that they got 1. Are you all talking about Karen Reed? I saw that they got 1. they got to even better. I don't know. Listening to, what does that mean? Are you saying, Twiz, you want me to text you when I'm going live? You're so funny. Right? James says, get Twizzle the shock balls. Oh, you were at the gym. Oh, that's good. Awesome. Love that. That's awesome. Meg, this mom sleeps through the stream. Oh, that's hilarious. That's hilarious.
Sheriff's office, if they want to, they can position a couple deputies in the back if they want additional deputies.
Well, their recommendation was that you wouldn't have to use the belt at all if they had the armed guard.
I read their response and their
See it. I was teaching. I must have accidentally clicked so that it doesn't show that there's a new message or whatever. I didn't see it, or I would have texted you back. Oh, you were going to listen while you were. For some reason, you're reminding me of Heather. Oh, wait, it's the all caps. That is really funny. I see. Okay. That's really funny. That's really funny. I mean, but you could also, I mean, I had the live stream set up by then. You probably could have looked and seen it. Anyway, from now on, I will text you.
their recommendation, and that's my order.
So what is it exactly?
That you have to wear the rack belt, but not the leg restraint.
And that they will or will not have armed guards?
It's up to them.
Okay.
All right. So tomorrow we're going to start at 10:30 with going through the answers on the questionnaires that the walk-in jurors will fill out in the morning. And then in the afternoon, we'll have in-person voir dire of those potential jurors. The court's going to seal the FTR tomorrow for the portion of the in-person answers of the jurors, which should be from 1:30 on. All right, we'll be at recess.
Okay, so now let's see what Nate Eaton has to say, since he's in the courtroom and he was a topic. So that hearing again was from yesterday. Okay.
Shout outs at the end of the program tonight. Let's just jump right into it. Today, we have a jury. We also have Lori questioning the jurors, as I mentioned. What's different in this trial versus the trial in Idaho? There have been some drastic differences that I want to talk about, especially for those of you that might be thinking about coming to Arizona to witness the trial over the next few weeks. Will Lori put on a defense? It seems all along that she is prepping for something, as she had witnesses.
The picture of her. Da-dum, 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 bum, 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 bum. I mean, look at that picture. It's just like, there she is.
She's, wanted to call her experts, but yesterday that kind of fizzled in a way. Her witness, her expert witness, isn't going to be allowed to.
So literally, this is what I was saying, right? In the hearing, I was like, that we just watched. I was like, I mean, to that end, I guess her mom and her sister, right? And maybe her dad. But other than that, she doesn't really have much going on. And again, that all, in my view, would make it even more likely that she would take the stand.
Be called in. And a lot of our other witnesses haven't been served subpoenas, haven't been found. So what are you going to put on for your defense? We'll talk about that. One-on-one with Rexburg Police Lieutenant Hermosillo. Of course, he's keeping an eye on this case, and he played a pivotal role in Idaho. He was the officer, the sworn officer who was in the court for Lori's entire trial back in 2023. He was there for every bit of testimony, every bit of evidence. He saw it all, the only officer that was allowed in. We, of course, will remember Charles Vallow, who is the victim of this case. And we have shout outs, cities, and your questions. So first off, the jury. Here is what we know about the jury. Well, let me kind of explain how the system worked first. So last week actually, several people in Maricopa County, hundreds, got questionnaires that they filled out. Do you know anything about the case? Have you ever heard the name Lori Vallow? Do you know JJ Tiley? If those questionnaires passed and were made it through, like all the questions were cool, Then yesterday and this morning, the
cool.
judge went through a list. He'd say, okay, juror number 2460 said that they've seen media coverage and they have a mother who has cancer and they need to care. I move that they are stricken for hardship. And the prosecution said,
James, you were here. We just watched this. She had Nate on her witness list, and that was BS. And the judge granted the state's motion to preclude him so that he's not on the witness list anymore.
Agree. And Lori said, I agree. And the person was removed. Once we got through that process, whoever was remaining in that pool came in this afternoon. And we had, I believe, I tweeted it out. I don't remember the exact number. I think it was 55 maybe who came in. And the goal was to get to 12 jurors and 4 alternates. And then they all filed in. We were, all the spectators, including the media, were put on the left side of the courtroom behind the defense. The jurors came in and they seated 17 up in the jury box. And then they seated the rest on the rows on the other side of the courtroom. And then the judge went through some very generic questions like, do any of you have a police officer in your family? And do you take the word of a police officer above the word of others simply because he's a police officer?
Yeah, so similar like
have any of you have family members convicted of crimes? Have any of you ever been convicted of a crime? These type of questions. And
Meg,
they would raise their numbers and
no
they would give it a
idea.
mic and they would
Meg is asking where did that mod guy go? I don't know if Kane is still here, but Kane, if you're listening, your odds are looking better and better. For 2 seconds to be like, why didn't you tell me you're going live? Oh dear.
Explain their thoughts on that. And then after that, the prosecution put on headphones hooked to a microphone, and the defense, Lori Vallow, did as well, and then the judge did as well, and then they played white noise over the courtroom. Now, this is what's called a sidebar. In Idaho, they did this a lot, and the attorneys would gather with the judge. The judge would step down from the bench, and they would gather in the corner. Lori, because she's the defendant charged with this crime, she can't approach the judge. She can't approach the witness. She's got to stay at the podium or stay at her table.
Are you talking about me or what? Like, I'm just saying that there's notifications in the Discord, and YouTube should give you notifications, but those don't always go through, but Discord usually does. Meg's putting in her application. Be mod.
In order to communicate effectively in a sidebar, you can't be yelling because people will hear. So they've installed this system, this headphone microphone system, and that's how they're communicating with each other during the sidebar. It's pretty interesting. And the white noise is very loud. We can't hear a thing. So they put on these headphones for about 5-10 minutes, and then the judge said, okay, the clerk, maybe it was the judge or the clerk, one of them said, the following jurors.
Sorry, I'm dying laughing. This is just cracking me up. Twins is like, would have been nice to know as I'm staring at my phone as I ride the bike. Twins, you know, you can just go to YouTube, right? And like, it should say that I'm live. Do you need me to like, you know, I don't even know. This is really funny.
Are excused. They let a bunch go. And then they sent everybody out in the hall. And then all the remaining jurors came back in and they were given new numbers. They were seated up in the jury box. And that was the focus for this first round, you could say, which ultimately ended up being the only round. And the judge asked them a few questions, but then Trina Kay got up to ask a few questions of her own. And she said things like, the Church of the Latter-day Saints, Mormons, LDS, it's going to be discussed in this trial. Do any of you have really strong feelings for or against the church? None of the
I remember Mike saying that.
Numbers.
Yep.
Do any of you own guns? Several raised their numbers. I believe 10.
So basically, we are just confirming. So YouTube, you know, notifications aren't always reliable. However, the Discord notifications always go through. But also Meg confirming that she did text you. She put out her bat signal. Also, I ran the calling all scrolls thing for that. That was at the beginning of the live stream, towards the beginning. So
do any of you are any of you considered an expert in guns where you might hear testimony of the way of
okay, I'm just skip ahead. I want to see where he describes who's on the jury here.
The tactic that Lori chooses to take during the trial, or if it's going to be the Lori we saw yesterday where she's fired up. Okay. Lori asks if they understood that it's the state's 100% burden to prove that she's guilty, and they did. She asks if anyone would have a problem if at the end of the state's case and they didn't prove that she committed a crime at all, they would think, I can't find you innocent until you told me what happened. She hinted at the fact that she might not give a defense. that if at the end of the state's case, if she
Oh,
feels
that's interesting. Okay, let's listen to this part again. You guys are cracking me up in the chat, but this is interesting. So he's saying that there's a question that Lori asked of the jury. And, you know, we wouldn't know this barring people being in the courtroom, right? Which is why we're watching this. So he's saying that there's a question she asked that hinted at she might not give a defense.
asked if they understood that it's the state's 100% burden to prove that she's guilty, and they did. She asks if anyone would have a problem if at the end of the state's case and they didn't prove that she committed a crime at all, they would think, I can't find you innocent until you told me what happened. She hinted at the fact that she might not give a defense. That if at the end of the state's case, if she feels like she does not have to give a defense or testify, if the jury would have a problem with that. None of them raised their numbers. So it got me thinking, I mean, she didn't do a defense in Idaho. Do you remember that? It was weeks and weeks and weeks of the prosecution, and then it was time for the defense. And her attorney said, Your Honor, we feel the state did not meet their burden of proof. We rest. Will Lori do that here? Will the actions of the past few months, with these motions and the experts and the witness,
I don't think so.
Calling me and all that, will that be just saying, well, never mind, they didn't prove their case?
I don't think so. I don't think she will, and here's why I think that. Because the reason that happened in Idaho, right, is because it was clear that she did not want to throw Chad under the bus, right? And if she couldn't have it her way, she didn't want to do it at all, right? Like a toddler. And so that's my interpretation of what happened in Idaho. Now, I think that when you take that same line of thinking for Lori, you apply that here, oh, could this be why she's going pro se, right? Because she wants it her way. And she learned her lesson in Idaho, for her anyway. Like, if she wants it her way, she's going to have to represent herself. And we all know she has a certain narrative she's going to try to peddle with throwing Tylee under the bus here. You know, she was not going to throw Chad under the bus, but she's willing to blame Tylee and lie about that and make it seem like Tylee was, you know, it was all Tylee's fault. So also I have some thoughts about speedy trial here. We're going to talk about in a sec.
I could see it happening. Or I could see Lori trying to put on a defense. I don't know who she's going to call.
She's going to. I think she's going to. I think she's going to. I think she would have in Idaho. I think she wanted to in Idaho, but because she couldn't do it her way, she didn't, and that's her being stubborn.
But she did ask that question. She said it's human nature to want to hear both sides. Then she asked and said that a bunch of different family dynamics will be introduced at this trial. Oh, and asked if anybody would have a problem, and then she stopped. Would anybody have difficulty understanding different family dynamics? And she asked if anyone in the jury had stepchildren, I think is how it was phrased. And several raised their numbers. And then she called on.
I think I know what she meant by that. And just the family dynamics. God. Trying to make it seem like there were issues between Tylee and Charles, and that Tylee was a bad stepdaughter, that type of thing, or that he favored JJ. All these different things that we've heard her echo at before. I mean, even think back to her interrogation, guys, in Gilbert, right? Did we watch that entire thing yet? I think we did. Did we watch that? Y'all let me know if we watched that or not. I can't remember now. But we watched the body cams. No, we did. We did watch it. We did. Now I remember. We watched it when we watched the body cams, and then we watched her interrogation. Right, we did. Anyway, but right off the bat, you hear her first thing. It's like Alex with the boat case. My son was in a boat, right? It's like that. That's her with like this alleged, volatile relationship between, Tylee and Charles. And that's like her first thing right off the bat she gets out. So anyway, I think that's what she's setting it up for from jury selection, potentially.
One to answer, but she couldn't really say the question. And the judge had to jump in and basically say, will your family dynamic of having stepchildren or whatever influence you in how you rule in this case, how you decide? And he explained, no, it doesn't, it won't. And then I thought Lori might jump to the others, but she didn't. She just called on the one and moved along with her questions. She asked, she said, if someone believes.
Oh, welcome. We have a new scroll from welcome to Heroes and Villains. Let me see what you guys are saying in the chat. Oh, thank you so much for the super chat there as well, James. Right, she needs to talk too much, definitely. And that's the thing. It's like that's where the stubbornness comes in, right? Because if she really does want to talk, but if she can't say what she wants to say, she's not going to talk at all, right? Welcome, heroes and villains. New squirrel friend in the chat, saying that Lori's innocent. April Fools. I can only imagine. Oh, is it Flash? Did you make another account? That's funny. That's really funny. I believe it. So Flash made an alt account. Love it. I'm just seeing what you all are saying. So, okay, let me keep playing this.
This was, I thought, a good question. She goes, if you believe that I'm innocent and you're the only one in the group, will you have enough courage to stand against all the other group? Because that can be hard. I thought that was a good question. She said, that's hard. Nobody raised their hand saying that. She then proceeded to tell the jurors what part of their job was, and Trina K objected, the prosecutor. The judge stepped in and said, your job is to determine if the state proves its case, jurors. That's your job. I've already told you your job. I should have said this was after the judge went through lengthy instructions about, you have to, anything that you've heard outside the courtroom, you can't bring in. You have to follow the rules of the courtroom, regardless of what you think the rules are or what you might have heard or what people have told you. You have to stick what's in the courtroom. So the judge kind of jumped in. Lori repeatedly took off her glasses, would refer to her notebook, would put them on. I guess vice versa. She'd put them on to read and then take them off to talk to the jurors.
Oh, wow. She's like taking well, I don't know if she was able to watch any of the Alec Baldwin trial. I would say taking a line from or whatchamacallit, a line out of Carrie Morrissey's book with the glasses. You guys remember how she used the glasses as a prop?
She asked if people understood what conspiracy is. And if you did not see or hear a specific agreement, if because there wasn't like a written agreement or some sort of agreement, if it is still conspiracy, nobody raised their things, their numbers. She asked if she did say this is a case.
They didn't raise their things.
Where religious beliefs will be discussed a lot. Do any of you have a problem with that? Will it be difficult? Nobody raised their cards. Is there anyone that has had an understanding that the judicial system works differently than the way it's been explained to you today? Nobody raised their cards. Lori asked if anyone would have a prejudice if she again did not testify, and then she was done. I think she questioned maybe 10 minutes. I think Trina K questioned maybe 10 minutes. This judge moved fast. It was so nice. He wanted to get that jury seated. So after that, those questions, back on the white noise, back on the headphones, and then after 5 minutes, the judge said, all right, we'll number whatever she was, a woman who had said she had previous knowledge of the case, I believe through media. He said, will you stand up? You're excused. And everybody in the benches and the seats in the gallery, you're excused. And the people who are here, you're the jury. That was that. So what do we know about the juries? We have 13 men.
This is what I want to hear.
3 women, a variety of ages, a variety of races.
There we go.
Alternates will be selected by lottery at the end, much like Idaho. They will all sit through the trial. They will all listen to everything. And then at the end, by a random lottery, the clerk will pull out the numbers of who the alternates are. Now, if a juror gets sick, if one gets in trouble for talking about the case, if one comes in and says, I watched Courtroom Insider last night, then the alternate, they'll be dismissed. The alternate will take their place. That happened not at all during Lori's trial 2 years ago, but Chad's, we had a juror who got sick. And I remember talking with the other jurors and they said he felt horrible that he got dismissed. Like he felt so bad. He wanted to do it and felt it was his duty, but he was just so sick he couldn't.
I thought it was really interesting.
So
after Lori in Idaho, right? After Lori's trial, there was only that one juror who spoke out. The one who was like writing a book and whatnot. I forget his name, but shout out to that one juror. But after Chad's trial, it was like nearly the entire jury, if not the entire jury, like the whole group of them, which is really interesting, right? I just like psychology wise, like that's really interesting. Like, I don't know. Yeah.
They cannot talk with anyone about the case. I think the judge stressed this 5 or 6 or 7 times. He said, you can tell people I'm on a jury and it's lasting 5 to 6 weeks. That's it. He said, if anyone tries to talk to you about the case, walk away. If something comes up on your phone about
run away,
about the case, get out of it. If something comes on the TV, turn it off.
If something comes up on your phone, throw your phone out the window. If something comes up on the TV, set the TV on fire.
He repeatedly said, you cannot talk to anybody about this case. I think he stressed it more than in Idaho. I mean, he really, over and over and over, you can't talk to anybody. We'll talk in a minute about the differences between Idaho and Arizona. Also, an interesting fact, these jurors, if they qualify and want, they get $12 a day. And they get reimbursed for their mileage, but they can also qualify and request up to $300 a day.
That's better than most places.
There's a jury fund to help, and several of these jurors that did make a difference, where they were worried that they would have to miss work and they don't get paid jury duty, and because of that, they couldn't serve. But then the judge said there is this pool, $300 a day that you can get, and plus you can get your $12 a day. So $312 a day. I should say up to $300 a day. And just some quick math here on my iPhone, that's $78,000 a year. Not that anyone's ever going to serve a whole year on a jury. Plus you get Fridays off. But that is nice to know. And that brings me to a topic, kind of a pivot here. Do you get paid jury selection with your job? Do you know? A lot of people, it's up to the company. Legally, in most states, probably all the states, you cannot get fired for going on jury duty.
This is a good point.
But employers, at least in Idaho, don't have to pay.
Yes, that's a good point. That is true. You cannot, no job can fire you for jury duty, but it's true. I don't think that there's any state that requires, actually I'm positive, no states require any business to pay you for jury duty, right? So the requirement, so again, no job can fire you for jury duty, but in terms of if a job's going to actually pay you, like your job, your salary while you're at jury duty, that is up to the employer. And that came up in, which case was it? I'll have to think about it. That came up in one of these trials. What was it? It might have been Jay Kowalski v. J Hatch, where somebody was employed by some huge company that obviously had all this money, and they put pressure on the company, like, are you really not going to continue to give them jury leave because it was one of the places that pays you for it. Anyway, so it's up to the company, but it's always a good thing, right? I think it looks good. If you're the company, I think it looks good to be like, we support we support the justice system. And so therefore we are going to, compensate our employees if they have jury service. But anyway.
Jury duty. Some states, I would imagine the laws do require you to get paid. If you know, put in the comments if you know what your state's laws are. Might be good to do some research in case you get called.
I don't think any state requires it.
It's quite common for these juries to have retired people or elderly people because they have time. They don't have jobs, and sometimes you will have. I'm thinking of the other cases in Idaho where there were retired people. There were some executives who got paid jury duty at larger companies, and then college kids or younger adults. There were some college kids who had to leave because they have finals and classes and whatnot coming up. So these jurors, if they want, in addition to the $12 a day, and they will get fed lunch, will get $300 a day. I mean, the judge even said, if you are at a restaurant and someone comes up to you and says, have you heard about this Daybell case? Do not speak to them. And he said, don't even give the appearance. If you're out in the hallway and like you see someone associated with the case or a reporter, he didn't say a reporter, but he said, if you see, don't speak to them. Don't even say hello. Even if you're not talking about the case, just ignore them. I'll tell you a story. I told this last year. Years ago, we had a reporter covering a story with a sex offender. During the break, our reporter was in the hallway and so were some jurors. He went up and he started making small talk. Hey, how you doing? Whatever, small talk like you or I would do just to be friendly. They go in the courtroom. The defense immediately stands up. Your Honor, a reporter was talking with a juror. I want a mistrial. The judge had to call our reporter back into chambers with the prosecution and the defense, and the juror said what exactly happened. Our reporter explained it. We ended up writing a story about that incident so that we were transparent. Luckily, the case was not thrown out. The judge said, okay, nothing nefarious was bad here, but could you imagine had a reporter resulted in a mistrial simply because they were doing small talk with a juror? So that's like how important it is with these type of things.
Yeah.
Okay. And the last bit of advice. So they were sworn in. I should say they were sworn in. That group was sworn in. And then the judge read them probably 5 or 6 pages of jury instruction. And again, stress, don't talk to anybody, but he talked about You know, you have to follow the law. If you have questions, put them on note cards and pass them to the court staff. The judge really kept things moving. And the jurors now have the rest of the week to get their affairs in order, let their workers, their employers know they're not going to be in for a few weeks, 1 week up to 6 weeks. We'll see, make family situations, whatever they need to do. And they will return on Monday. There won't be any court until Monday. Now, here are some differences between Arizona versus Idaho. And I want to make it clear before I dive into these, that we're talking very different charges here. And several of you are like, what? They have a jury in a day? Like, what? Like, how does that even happen? And is Arizona even taking this seriously? Seems like they're rushing through this and blah, 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 blah. Lori Vallow was charged with multiple counts in Idaho, including 2 murder charges, a conspiracy to commit murder for Tammy, and all of her other charges. Chad Daybell was facing the death penalty. The gravity of the charges are huge in Idaho. Not downplaying this at all. I hope it doesn't come across that way. But in Idaho, you were dealing with multiple charges. So simply put, that takes longer to explain it all rather than the one charge here. You just say the one charge. In Idaho, there were multiple charges. You have to explain it all. Plus, the jury selection pool here, so much bigger versus Idaho. There are more people in this county than all of Idaho. And I would say, I believe the media coverage has not been as intense here versus there. There has definitely been media coverage here in Arizona for sure. But in Idaho, this was the big story. And remember, the kids were found in Idaho. It was national news. There was a lot of national focus when the kids were found, when Chad and Lori were arrested. It was in Idaho. Well, she was in Hawaii, but brought back to Idaho. The court hearings were in Idaho. Charles was shot and killed, and there wasn't any real media attention nationwide until months later. And then there wasn't really much because Idaho was the focus.
Yeah, it's
so
a good
I think
point.
it was much easier to find a jury.
That he's saying here.
I will say too, there seem to be more resources, or the court system here, there's far more people to help, or they're used to these bigger type of trials. I mean, you should see the jury room. The jury room, I didn't go in, but you can see it when you walk in the first floor. It is massive. And they have a whole desk. I mean, it's a whole different game compared to the courts in Idaho, not bashing them. So I think that when I give these kind of comparisons, there are the differences. Here's just a few. The jurors in Arizona can question the witnesses. So at the end of questioning,
oh my God,
Lori,
that's
well,
awesome.
the prosecution, and then Lori, and then the prosecution again, if it's their witness, the jury can ask questions. This will be fascinating. They will write the questions down on a note, according to the judge, pass it in, and then the questions will be read.
Oh my God.
It's going to be fascinating. I didn't know this till today, and then someone told me that in the Jody Arias case years ago. This is what happened. By the way, this courtroom is directly across the hall from where Jody Arias was tried. And the court staff were telling me that during that trial, that floor, this is on the 5th floor, was packed with people. And they had a waiting area for media and a waiting area for public. And if someone got up in the courtroom to leave, they fill it. It was a whole system, and it was madness. We haven't seen that. And hopefully we don't see that here. But this is the same exact, and from what I understand, a lot of the rules changed as far as public and whatnot. After
I love jury questions. That is super exciting.
Jody Arias trial, things changed a bit. So jurors can question the witnesses here, which will be fascinating to see. Jurors seem to have more freedom. Now, don't take that wrong. What I mean is the jurors during the waiting times, the recesses, they were out in the lobby with all of us. I went out to use the restroom, and there's the jurors. I could have talked to them. I didn't say a word. But it's not in Idaho. They really, really protected the jurors. You never saw them in the courthouse. They brought them in on vans. I don't believe they're doing that here. They're going to drive in and get organized. I could be wrong, but I think they're just going to come to the downtown courthouse on their own. The jurors.
That's just cracking me up with this alt account. With this, is so funny.
It just seemed, I don't want to say more relaxed. Now that could change next week. Obviously, next week they'll have a separate entrance that they can go in and a separate exit. But it just seemed that this was a little bit more relaxed in a way. Less time at the courthouse versus Idaho. In Idaho, if you remember,
that's a good question from official asking. So if you violate jury duty stuff, you're caught talking about the case. So you don't get charged with a crime. You just get removed from jury duty. Now, depending on the level of interference, if you intentionally try to interfere with the process, they could hold you in contempt of court. But it's very, 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 very unlikely, if not completely unheard of. Because that's not a good standard to put forth, right? Jurors being held in contempt for doing something. So anyway, but yeah, so you would be removed from jury duty.
The trials was 8:30 to 3:30 daily with about an hour lunch. And the judge started right at 8:30.
No, not forever, but from whatever case it is that you're on, you know, you could still get called again in the future.
We were done at 3:30. The schedule for this will be 10:30 to noon, so 90 minutes, then a 90-minute lunch, 12 to 1:30, then 1:30 to 4:30 with a break in between. So basically 10:30 to 4:30, Monday to Thursday. Many of you are like, what? That's the easiest schedule in the world. You know, I've been here a few days and I can see why. Maricopa County is massive. If you've got to get your kid off to school and then you've got to drive downtown and get parking, I would imagine they have parking for them, but you got to get the kid off to school at 8:30, get ready for the day, drive downtown, park, you got to be there around 10 by 10:15. Then you got to get home. I can see why they would do this. It's so large. And believe me, my wrists are so happy with that for the typing and whatnot. But they will spend less time at the courthouse, and they don't do courts on Fridays. I think we've talked about that. Makes it easier probably to find jurors with that type of a schedule. Same rules we talked about.
Here we go.
Talk about the case.
There it is.
And we talked about Lori questioning the jury. So that is a recap of everything that happened today. Again, there's no video. I know what many of you want to see video. There was no video, and the judge has sealed the record with jury selection. But starting on Monday, we will have video every day, and you can start watching it on the East Idaho News YouTube channel at noon. Why noon? When court starts at 10:30? Well, 10:30 Arizona time is 11:30 Idaho time, and we have to hold the video for 30 minutes. There is a delay. Right at noon, that video will start. So be sure you subscribe and hit the bell so that you know when we're live, you can watch it. We'll actually probably start the live an hour before. I will be live updating and tweeting when the second court starts. So if you want to, you know, read and get caught up on what's happening and then flip over and watch the live stream, you can do that. All right, I want to jump into this interview with Detective Lieutenant Ray Hermosillo. He, of course, I mentioned earlier, was the lead detective on the Idaho case. And we Zoomed for several minutes the other day just to talk about the case, what he's looking forward to, if he thinks there'll be any differences, and also his thought on the Dateline interview with Lori. So here is Detective Lieutenant Hermosillo. All right, Lieutenant Hermosillo, here we are, third trial in a third year. Is there anything that you're not, I don't want to say looking forward to, but anything that you're anticipating to come out of this trial?
You know, Nate, I don't think so. I mean, we've heard a lot of what she said. I think it's going to be
This is Nate
pretty repetitive from the Idaho trials. I don't know that he would call himself a reporter. I think he would call himself a journalist.
And you know, I think there's a little bit of a difference, but also East Idaho News is not I don't know if they would even count as mainstream media. What do you think, Tonka? East Idaho News does a great job. And I really do love Nate Eaton. You know, I'm with you guys. Like I'm not a mainstream media person, as y'all know, and I don't, you know, but East Idaho News is a great resource, and that's why I try to use their channel, especially if it's just like a court feed whenever I can. And then, right, Nate Eaton does that thing where he surprises people around Christmas. Yep, he does. Yep, certainly does. That's funny. Yeah, so he's this case is his baby, right? He's been on this since day one. So, and I will say too, like that, you know, he's kind of like, if you were to compare it to Karen Reed's case with Turtle Boy, Nate Eaton really is the one who was the first on this case with Lori Vallow, who got it into the spotlight and kept it there, right? I mean, I remember, we talked about this before, but I remember those videos of him showing up on the tarmac in Hawaii. Lori, where are the kids? Lori, where are the kids? And I remember that. And it was like, that was what brought attention to this case. That is hilarious. That's hilarious, Flash. Yeah, MSM for Idaho. Yeah, that makes sense. That makes sense. But definitely not nationwide for sure. Right, mostly just in-state stuff. Oh, welcome, Northwest. Happy to see you again. The laundry community is very protective of Nate. Yeah, I guess that makes sense. I feel very protective of Nate. I mean, I think, you know, the thing about Nate is he's so incredibly fair, right? He's just a genuinely fair dude. And you don't ever see any bias from him, even with this case, right? Where, again, it's his baby. He's really, he does, I don't know, it's very unique. His demeanor is very unique. And there it is, Northwest saying, like, literally, Nate has old school journalism ethics, report the facts and bias. Yep, 100%. And he's very humble, and he's very just like a genuine, like, I love how he really encourages like the dialogue, right? And when he doesn't know something, he says so. And I don't know, there's just a lot of good things you can say about him. But first and foremost, the unbiased, reporting is huge. He owns it. I did not know that. Twiz, what are you doing? Twiz. I didn't know that, if that's the case. But I wanted to just talk real quick about the speedy trial thing. So here's what I think is going on with that, because Lori, a few hearings ago, right, the judge was like, when she wanted to bring in that expert witness to go and have all this shit celebrated, right, the computers and the phones, and it was like, look, Lori, like, you can like waive Speedy, right? Like, you can ask for more time to, and like the judge was really trying to like, he wasn't trying to talk her into it per se, not even per se. He wasn't trying to talk her into it. He was just mentioning it. And she was like so stubborn about it, right? Nope. Right. I'm going to go to trial. And it's just one of those things where it's like, why is she fucking doing this? And here's what I was thinking about this today. And I think that it's misguided. And I think this is Lori brain, Lori thinking. Here's what I think is going on with her. I think that she thinks, given her limited understanding of the law, I think that what she thinks is that it's going to be an issue on appeal. I think that what her potentially, this is just my personal opinion, that her understanding, okay, of when you're a defendant, right, and your rights come first and foremost, and then when you're add to that a pro se defendant, right, you know where I'm going with this, right? You're a pro se defendant, and it's like, okay, you have every handicap in the book, right? And then I think that where she, and again, it's misguided, right? But then her thought being that she can be like, here I am, a pro se defendant, and I had no choice but to go to trial. I shouldn't have to waive my right to a speedy trial and without understanding how the colloquies work, right? And this is where I'm going with this, because all the colloquies, like, in other words, she's trying to make it seem like has all these different disadvantages and that she was, her rights are being violated left and right, potentially, right? However, completely forgetting about all the colloquies. For example, representing herself pro se, that's her choice. Maintaining her right to speedy trial, that's her choice. If she takes a stand, that's her choice. All of these things that are her choice, and that every single time she's agreed to it. So I don't know. Is that making sense? Lori's dad is soft sit-ish. Yes, definitely. I did not see that. If you know where I can find it, I haven't even heard about it. So, I mean, we watched, if you're a friend who was just not, we watched the hearing from the 31st, but that would have not been from today. So, but yeah, her dad is, Twiz says he's not biased about maps. Oh, I see what you're saying, Northwest. Okay. Yeah, no, I haven't seen it, but again, it would have, if it had happened, Nate would have been talking about it, So, okay, so that's what I wanted to say, though, about the speedy trial. I think that it's a misguided attempt on her part, thinking that it's going to help her on appeal, right, for this case, to be like, look at how much my rights were violated. Here I am, a pro se defendant, and I'm being pushed to go to trial and not given enough time to get my expert to go through and do the celebrate and all that, right? That's what I think she's going for. And in other words, if she were to waive Speedy, then she can't be like then she would have had time. Like if she waived Speedy, then she'd have time to get her expert and all that. And then by maintaining Speedy, it's like, look, I wasn't even given time to get my expert done. But see where there's the flawed logic there because it's her choice. And so, so I think that's her misguided attempt, thinking it's going to help her on appeal potentially. But guys, we will save Detective Hermosillo for another day. And that's the other thing too, right? Correct. And it wasn't just that though; it was the disclosure violations. But it did help her in Idaho to a certain extent. But as far as getting the death penalty off the table, that was for the expert disclosure violations. But I could see her being mistaken and thinking that it was the speedy trial alone that helped her in Idaho, even though it's completely different. Merry Christmas, Happy New Year's, always. So, okay, so we will save him for another time. So now what we're going to do is it's going to redirect you guys through the magic of the portal into the next stream. Woo! Right. So, right. And so again, that's why I said that it would make sense if she was confused and thought that it was the speedy trial that got her the death penalty off the table. It was the disclosure violations that couldn't be fixed in time for Speedy. So it's related, but not because of that. You know, in other words, even if you don't, even without speedy trial in place, right? If you violate a deadline at any point in time for a death penalty case, it could result in the death penalty coming off the table. So, good night, Flash. So, oh, what Tonka looking into things. Thank you, Tonka, saying, I can't find any verification that Nate Eaton is the sole owner of East Idaho News, but it does look like he's the principal shareholder. Okay, thank you, Tonka, for looking into that. So, okay, through the magic of technology, we are going to portal on over into the next live stream. So love y'all, and I will see you guys here in just a second.